All right, everybody, here we are. Happy Saturday. It was a cool day today. I got up about 5 a.m. and did a bunch of yard work before it got hot. Weird, unseasonal hot swing today. Got a bunch of firewood cut. It's going to be cold the next couple weeks down here. So I got a bunch of firewood cut, got weeds whacked and lawn mowed and a bunch of garbage around the house cleaned up. Then I came into the office, got here about 10, and had a meeting, client meeting at 11. That lasted about 2 hours, so I was done by 1. And then I got some work done today. I probably got like 4 billable hours in today working on an opposition in a big wrongful death case that we're working on up in Contra Costa County. But other than that, I had a pretty uneventful day. Hope you all enjoyed your Saturday. Tonight, we're going to have Volume 1, Part 6, I believe, of the deposition of the lovely and so talented, although illiterate, because, right, she gets disciplined for grammar errors that are really not grammar errors, but are just out and out lying in her reports. But whatever, man. That's Maisha Hammond, the one and only. PayPal. You guys got to know about PayPal donations. Anybody that wants to contribute to the project to keep it all moving forward and help us out on that, just posted a PayPal link. Any and all donations are very much appreciated. There it is on the bottom of the screen as well. And what else do we have here from James? Patreon, for those of you who are either pro se plaintiffs or attorneys looking to get into this type of work. And by this type of work, I mean suing Child Protective Services for civil rights violations. We are posting all of our work product on Patreon. It's a subscription service, but we keep the prices low, so it's very affordable. Parents and attorneys, everybody can afford everything we've got there, but there's a lot there, so you should take a look, check it out. It's worth it, in my view, if you're getting into this type of stuff. No reason to reinvent the wheel on anything. We've done a lot of research. We've made or opposed nearly every motion you're ever going to make or oppose in one of these cases, and they're basically up on Patreon for the taking. But yeah, anyway, if you guys have any questions as we're going through tonight's stream or anything else that you've seen or heard on the channel, or even things you might have not seen or heard on the channel, I'm very open. I'll even talk politics, even if it's politically incorrect. I really don't give a shit. Do you have a question? I'll answer it with my opinion, but you might not like it. So anyway, it's open game. capsandstems.gmail.com. Send in your questions. I just posted it both in the chat and at the bottom of the screen. Yeah, anything you want, ask it, and I will respond. Let's see what we got here. Anything else? I have nothing else for you in the read on. Oh, other than the AI model for subscribers. Actually, how can I do this? Let me do something real quick because I want to put it out there for you guys so you can kind of check it out and give us input on our AI model. You can get on and screw around with it and let us know what you think. So I want to copy the link and I'm going to paste it into the chat. That is the link. And the username is Patreon, Patreon, and the password is CPS sucks. So if you guys can get on there, check it out, let us know what you think, give us your input, would be very much appreciated. Starlatech, yes, I did hear about the Alabama Supreme Court, and I wondered about that. If an embryo is a person, does that mean a pregnant lady can use the carpool lane? Because, technically, there's 2 people in the car, right? And then a secondary question I had is, say I'm in a lab. Maybe I'm a lab tech, and there's a fertilized egg in a test tube or a petri dish, and I drop it and shatter it, and it kills the egg, just makes it unviable. Have I just committed murder? It's like, holy shit, or homicide at least, maybe a manslaughter, something like that. Or if I just flush it down the toilet, is that an abortion? I don't know. I think the decision gives rise to more questions than it answers. And I think it was an imprudent and unwise decision to make. I believe it probably will go all the way to the Supreme Court, and I believe it probably will get reversed. I think that's the decision's just backward ass craziness. But that's just my opinion. I mean, everybody has their view. I know there's some right to lifers out there that say, yeah, moment of conception, the moment that you have that spark between a sperm and an egg, even if it's in a test tube, you've got a human being there. So, you know, I guess the way I would look at it, I don't know whether that's correct or not. But what I would agree with is that the moment that egg is fertilized, you have the tremendous potential of a human being there. I don't know that you necessarily have anything viable. And, you know, lots of people have potential that's never exercised. So I don't know, man. That's a deep philosophical question. But yeah, I think it's a wrong decision. It's wrongly decided. It was imprudent, and it's probably going to go all the way up, and it's probably going to get reversed. That's my view of it. I think that I don't know what the fuck the panel was thinking when they came up with that. Frankly, it's a problem. Anyway, let's get on to our stuff. No need to delve into that too deeply because it doesn't really impact it. Well, it does actually. What happens if you have a egg that's fertilized and it's at the lab still, and the mom gets rolled up for, say, drug abuse, and somehow CPS finds out there's this egg, this fertilized egg in a petri dish in a lab. Can they file a petition? And then if they do file a petition and it gets granted, is CPS then responsible to find a host body for that fertilized egg? I mean, since it's a person, it's a child, I guess. I mean, do all the child protection statutes apply and come into play? Fuck, I don't know. See, that's I don't know, man. That's just some crazy shit. But again, until I get one of those cases, I'm really not going to worry about it. In fact, this conversation here is the most I've thought about that issue since I read the decision. So anyway, here we are. Meisha Hammond, Volume 1, Part 6, I believe. He has it labeled here in my read on as Part 5, but I think we did Part 5 last night. She's 30 minutes long, and it's just going to be more of the same shit. This ditzy woman lying to us as we work our way through her depo. So anyway, let's get to it. Here we go. And yeah, I agree with you. I think it's ludicrous. The decision, that is, I think is just craziness, probably politically motivated. But, you know, who knows? It's not going to go anywhere, is what I think. Here we go. Meisha Hammond.
Question. Okay, so the place that we would look to get the specific facts to justify the unwarranted seizure of a child would be your Springer narrative?
Okay. So the place we would look to get the specific facts to justify your unwarranted seizure of BR in March 2010 would be your investigation narrative.
Correct.
Okay. Anywhere else?
And specific to me, my report?
According to your training, is there anywhere else that you're required to document the facts that give rise to an exigency other than in the screener or investigation narrative?
Well, in every subsequent report,
Okay.
court report.
And in all of those, according to your training and the policies in place in Orange County, you're required to be truthful, accurate, and complete in your reporting, correct?
Correct.
Okay. And one of the things that they were harping on here, I don't know if harping is the right word, one of the things they were bringing to your attention here in this August 16th, 2010 notice of intent to suspend, it's Exhibit 46. One of the things they were bringing to your attention was your failure to be complete, honest, and accurate in your reporting, correct?
Correct.
Okay, it wasn't just grammar and spelling errors, correct?
Correct.
Okay. You understand through your time with the agency that the community, Orange County, the citizens of Orange County, this community, they rely on social workers and the department to be honest and fair in their treatment of parents that come and children that come before the agency, right?
Correct.
Okay. And you also understand that your failure to be truthful, honest, accurate, and complete in your reporting potentially undermines the community's confidence in the agency, correct? I mean, that's why they were sending you this letter. Am I right?
If you know.
I don't know. I don't know why they sent me this letter.
Okay, this letter giving you notice of their intent to suspend you, you don't know why they sent it to you?
I have
This crazy woman, man. Batting her eyelashes isn't gonna help.
I don't even know how to respond to that. I don't want to launch into this another whole discussion that's irrelevant to this proceeding. So that's why.
Why did they send you this notice of intent to suspend? That's a very simple question. If you don't know, you don't know. If somebody told you why they sent it, that's a
Because they
different
felt the need to do that.
They felt the need to do it.
Yes.
Why did they feel the need to do it?
Well, they explained it in the letter.
Okay. And when you say they, who's they?
At the time was my program manager, Christine Smith.
Okay. Okay. Is one of the reasons they sent you this notice of intent to suspend because you did not thoroughly investigate the child abuse referrals that were assigned to you?
Well, cause for speculation. This witness lacks foundation. Document speaks for itself.
Go ahead.
Is that your understanding?
That's my understanding. Document speaks for itself.
Okay, well, let me see if I can't refresh your recollection. If you go down to the bottom of page 00186, last complete sentence there says, based on the review of the investigation narrative submitted to your current supervisor for closure and the answers you provided in the investigatory meeting, it appears that you did not thoroughly investigate the child abuse referrals listed above. First, did I read that correctly?
You did.
Secondarily, does that refresh your recollection as to why it was that you were being provided this notice of intent to suspend? At least one of the reasons.
It's the reason that they wrote on the paper in the letter.
Was there some other reason that's not disclosed on the face of the letter?
Calls for speculation. This witness.
If you know.
It would be my speculation.
And your speculation is what?
It's irrelevant because my suspension was reversed, so I'm just going to leave it at that.
Who reversed your suspension?
The county.
After how long?
I don't know. I don't remember the exact time.
Were you given back pay?
Yes.
Okay. Was there litigation that ensued as a result of
No.
that? Was that an action through your union?
Yes.
Okay, so the union jumped in, defended you, and got your money back for the suspended days?
Yes.
Okay. Were you required to go to any further training as a result of this notice of intent to suspend?
Absolutely.
Right. This is what I want to let you guys know, is this is what happens with these workers. There was a case in LA, Gabriel Fernandez, some of you may know about it, where the workers did the same sort of thing, lied about doing visits, lied about investigating abuse allegations. The kid ended up getting murdered by the mom and the boyfriend after 60 child abuse complaints where the workers lied about going out and checking it out, investigating. They were actually charged with murder. And they were fired. The union got involved. All the workers got their jobs back. Criminal prosecutions were dropped. They got back pay, even though they effectively murdered this kid. So that's what happens is every social worker I've ever sued, every one of them, they get promoted, number one, or they get a lateral move so that they're out of a position where they can incur liability. But they never get suspended. They never get fired. They never get disciplined because the union steps in and covers their ass. So, and again, this is getting into politics, but I see no legitimate purpose for municipal employee unions. There should be no unions in government employment, period. And as long as there are, we'll have a corrupt system. And that it's just that simple.
Absolutely not.
Okay, so you had no further training on the importance of honesty, thoroughness, and completeness in reporting?
Well, I go to my own training, as you can see from the training partner. So I'm sure documentation and report writing's in here, but that's from my own choice. I like to go to training. I love training.
So you weren't directed as a matter of discipline to have further training?
None.
And going back again to this concept that you were being disciplined only for spelling and grammar errors, remember that testimony?
Yes.
If you can look at the bottom of page M800187, and the last paragraph there, it says, your inaccurate documentation of fundamental investigation facts in your investigation narratives as described above is unacceptable and makes it very difficult for a supervisor to determine if you adequately investigated and assess the referrals assigned to you. First, did I read that correctly?
Yes.
Okay. Is that another one of the reasons that you were being provided with this notice of intent to suspend, is because it had been discovered that your documentation of fundamental investigation facts was inaccurate?
It's.
That's what it says.
I'm just going based on everything that it says here. Is that's what they say. That's what they say.
Did your supervisor participate in this at all?
No, she was in one of the meetings, but she had been my supervisor for maybe 3 weeks, a month.
Okay. Who else was at the meetings? Obviously, this Miss Smith would have been at the meeting, right?
She was there. I don't remember. I would just be looking at the names on the back of the page.
Okay. And
7 years ago.
all right, let's see if we can't figure out who these people are. Gary Taylor, was he at the meeting?
No. Oh, you know what? I'm sorry. It's none of, and neither was Ray Gallagher.
Okay. What about Regina Armstrong?
Yes.
Okay, she's the only other one listed there.
I know this was the letter. So they send this letter out, and then I believe I had a meeting. Mm-hmm. I don't remember who was all, Colette Farnes, who was the HR person.
Okay. Did anybody stick up for you at the meeting and say, oh no, she's not being dishonest or inaccurate?
And my OSHA rep.
Oh, your union rep.
Yes, union rep.
Okay.
I forgot her name.
Was that an attorney?
No. I mean, I don't know. I don't believe she was an attorney. She just,
Okay.
I think so.
Okay, and then did you respond at all to this letter?
I did.
In writing?
I believe I did.
Okay, responded in writing. I'm going to want that.
And then I went to a hearing.
I understand. Do you know if there was a transcript of that hearing?
I don't know.
Okay. Is that the only time that you ever faced any disciplinary proceedings?
Yes.
Okay. I'm going to show you what we'll mark as exhibit number 47 to your deposition. Let's see which one is which. I guess they're the same. There you go. You recognize exhibit 47?
That was her. I did this. Oh, okay. Yeah, I think. Okay.
Do you recognize exhibit number 47?
Yes.
What is exhibit number 47?
The follow-up after this hearing.
The follow-up after that hearing, so it's the same referral you're talking about?
Yeah. This is the notice of intent, and this is the notice of suspension. That's why it's the same 10 days
Okay.
after.
Okay. Okay, so you had your hearing.
Yes.
And then they suspended anyway.
Yes.
I gotcha. Do you recall ever having received any letter of reprimand or any kind of critical letter in relation to your handling of the Jill Randall matter?
Yes. I forgot what that's called.
Okay.
It's not a disciplinary action. It's a memo of understanding, maybe? I don't remember.
Hold on one second.
Memo of expectations.
Okay.
Okay, I'll show you what we'll mark as exhibit number. Actually, let me look at 47, make sure there's nothing else I need to do on that.
Summary conference. It's called a summary conference.
Okay.
Sorry.
Let me ask you before we move on from exhibit number 47, do you recall that there were some findings or determinations made as a result of your hearing?
Yeah, they suspended me. Is that what you mean?
Okay, yeah. So you do recall that?
Yes.
And you also recall and understand that the reason for the suspension was because the hearing officer concluded that you have not adequately investigated or documented your investigation of the cases that they discussed in that earlier letter, exhibit number 46. That was the
Yes.
finding? Mm-hmm. And also, as a result of that finding, you were directed to make immediate, substantial, and sustained improvement in your work performance and adherence to all CDSS regulations, SSA administrative policies and procedures, and CFS policies and procedures, correct?
Correct.
Okay, and you're saying that you exercised your right to appeal that decision, correct?
I don't remember if I stopped here. I don't remember. I don't remember. I don't remember.
Okay.
I think that was the hearing was before, but I don't remember.
Okay, that's fine. All right, moving on to exhibit number 28. Oops, we'll have to come back to this. Okay, do you recognize exhibit number 28?
I do.
And what is exhibit number 28?
Summary of conference.
Okay, and what was the date of that conference? When
March Sorry.
Sorry, when did it actually happen?
Well, I never had a conference. I just got an email.
Okay. And what was the email? Was this the email?
Yes.
This says it in the upper right-hand corner, attachment 7. You see that?
Yes.
What was it attached to,
Nothing.
if you know?
I don't think anything. I think I just got an email.
Okay. And you never had any kind of meeting or anything in relation to this memo?
I did. I actually went to speak after I got the email.
Okay, yeah, thank you, Bill. Mr. Halleck just handed me, is it this number 7, March 29th? I presume it is.
Yeah, March 29th, summary of conference.
Okay.
That's,
Yeah, it's
when
a,
they do a notice of intent to suspend or discipline, they will have all these attachments. They mark them as this is marked Exhibit 28. This attachment 7 would have been attached to the whole package that goes to the employee as a notice of intent to suspend.
got
Give
it.
them the right to the Skelly hearing. Then they come out with the discipline, whether it's modified from the notice of intent to suspend or not.
Okay, I got it. Thanks for that. Just so that we're clear from the witnesses that your understanding that this March 29th memo that we've identified as exhibit number 28 was in fact attached to, or was attached as exhibit number 7 to our exhibit at your deposition number
46.
46. And it's right there if you want to reference it.
When you gave it to me. Is that what you mean?
No. Actually, when I gave it to you, it's coming separate. I don't think we realized at my office that it was all part of one document.
Oh, okay.
So when I gave it to you, it's actually 2 separate exhibits, and that's what I'm trying to get you to verify here today, is that what we've marked as exhibit number 28 is in fact attachment 7 to exhibit number 46.
Yes.
Okay. At that meeting that you had in relation to exhibit number 46, did you discuss this March 29th memo, if you recall?
I don't recall.
Okay. Why is it important that you do a thorough and complete investigation when investigating all suspected child abuse reports?
So you can make accurate findings.
Okay.
You're dealing with people's lives.
Okay, that makes sense. And that's important, right?
Absolutely.
To be accurate. Yes?
Yes.
And to be complete.
Yes.
And to be truthful.
Yes.
Okay. Because people's lives are at stake, basically.
Yes.
Families get torn apart if you're not truthful, honest, accurate, and complete, right?
Or get killed.
Right. Why is it important that you not form any preconceived dispositions for your investigations prior to actually interviewing and investigating all of the principal parties involved? Why is that important?
Because it can lead to bias. And you may not see everything if you have tunnel vision.
Now, do you recall having a conference with Mr. Michael Taylor on or about March 29th, or actually March 24th, 2010?
Yes.
Okay. Without referencing the document, let's just close it down for a second. What do you recall of that conference with Mr. Taylor?
Well, I recall one, him explaining to me the complaints that Jill Randall and her mom and everybody called the Board of Supervisors and were complaining. So he had informed me that everybody received all these complaints and what she was complaining about. It was a very informal meeting. That's all I really remember.
Okay. Did he ask you? Did he ask you about the events that happened the night of BR's seizure from his mother? Did Mr. Taylor ask you about those events?
He was at the TDM. He was the one who approved my narrative, so he didn't have to ask me. He knew it all.
Wait a minute, he was at a TDM?
Yeah, he's my supervisor.
So there was a TDM in the Randall case?
Yeah. Well, we attempted to have a TDM.
Okay, explain to me what happened there. You made an attempt to have a TDM, mom showed up at the TDM, and what happened from there?
Dad was there, grandmother, paternal grandmother was there. We were, Mike and I, okay, so now I'm remembering, I'm sorry, I'm bringing it back. We didn't have the TDM
Right.
because the case was dismissed.
Well, let's try this again.
So they, I don't know.
Hold on. There was no case to dismiss, right? You never filed a petition.
Yes, so the petition was dismissed.
Is there a court order somewhere dismissing a petition?
The blue, you write it on the blue, petition.
Okay, hold on. You understand petitions get filed with a judge, with the court, right?
Yes,
And that is what starts a juvenile dependency case moving, correct?
Yes.
Is it your testimony here today under oath that a petition was filed with the court in Jill Randall's case?
It never went to that far.
Right. So there was no case to dismiss.
The petition was dismissed.
There
Or
was
my
no
application for
you
petition,
fucking
sorry.
idiot.
Okay.
That's our form.
And the reason that you never filed a petition to initiate a juvenile dependency case was because you sent Adam Randall into the family court to get a temporary protective order.
No.
Okay, explain to me what happened there.
The father went to family court and gained, I don't know if he got a restraining order. He got obtained custody. I don't know what all the words, everything that he did.
And he did that because you told him to the night that you gave him the child, right?
I don't remember all the specifics, our specific conversation, but he went to family court the very next day.
Okay. Did you do any examination of him that night before you gave him the child to make sure that he wasn't high? And by high, I mean high on drugs.
Well, I don't conduct examinations. I don't know what you mean by that.
So you might have just given this child to somebody who was high on drugs, drove to the location at your instruction, and then you passed the child off to him without any examination of him at all. Is that pretty much how it went?
Well, he didn't appear to be high to me or the local law enforcement that was with, he didn't appear to be high. I was there, 2 police officers were there. He didn't act erratically. He didn't look stoned. He didn't look high. But no, did we exhibit or have him complete a drug test? No.
In fact,
A failed sobriety test? No, we didn't.
In fact, you didn't even have him get out of the car, right?
I don't remember that.
Yeah, it was his girlfriend at the time that got out of the car and actually took the child.
Absolutely not.
Oh, you don't remember that?
No.
Okay.
I would never release to a girlfriend.
Well, they were there together.
Well, I wouldn't release to a girlfriend. I know that.
Okay. And you don't remember whether Adam Randall ever even got out of the car?
I don't remember that.
Okay.
I don't remember.
Okay. Have you ever read his trial testimony?
No, I haven't.
Has anybody ever told you that he was high as a kite that night?
Students Fashion on Evidence Lex Foundation.
My question is, did anybody ever tell you that?
That he was high as a kite?
Yeah.
No.
Jill Randall that night before you seized her son, when she was begging you not to, she didn't tell you that Adam Randall was a drug addict?
No.
You deny that ever happened?
I completely deny. She said he was high as a kite. I can't
That
imagine.
wasn't my question. Let's
That
have the
wasn't my
question
question.
reread.
Listen to the question.
Can I have the question reread, please?
I love the eyelash
Joe
flutter.
Randall that night, before you
That's a
seized her
skill
son, when she was begging
or
you not
talent,
to, she
I
didn't
guess.
tell you that Adam Randall was a drug addict?
I don't recall.
She might have, you just don't remember.
I don't recall.
Okay. Now, Miss Randall, she also told you that night that she had a active restraining order against Adam Randall, didn't she?
I don't recall.
I think we might have talked about this a little bit at your trial testimony. You do recall having reviewed some family law files with both Mr. Randall or Mr. Adam Randall and Jill Randall, correct?
And during a previous investigation? Yes.
And so you knew from that experience that there was in fact a restraining order issued against Mr. Randall by the family court, correct?
No.
Did you guys
Let's see if we can
watch
refresh your
Jack?
recollection. I'll show you what will mark as Exhibit 8 to your deposition.
I think she's wishing this was over.
Is this a copy for her or for me?
Oh,
You didn't make
you know
enough
what?
copies.
I did make copies.
Oh,
I was using yours. I'm sorry. I gotta find my Exhibit 8. It's just more convenient to use yours than it was to flip through my big book. Exhibit number 8. Okay. Do you know what that document is, Exhibit number 8?
A restraining order.
It's an order of protection.
Yeah. Yes.
That DV-130 up in the top left-hand corner, do you know what that means? Does that mean domestic violence,
Yeah, I was
if you
going to
know?
say I didn't want to assume, but yeah, domestic violence.
Okay. And Jill Randall, that night when you were out at her home, after you'd have already given Mr. Randall her home address so that he could show up and pick up the child, she told you that she had this restraining order in place, right?
Well, one, I didn't give Mr. Randall anybody's address
How did he know where to go?
because he had a regular visitation with his son.
But the pickup points for the regular visitation, ma'am, they were not at her home, were they?
I have no idea. I
And the-
didn't give him the address.
And the reason they were not at her home was because she had a concern about Mr. Randall knowing where she lived, right?
I don't know that.
Okay.
Okay, hold on, just to avoid some confusion. Lawyer Up's question is he probably knows he's not winning, and that's in response to Eric's comment about the lawyer doing an internal face palm. And just understand this idiot woman, she'd already been sued. We already resolved her case. We went to trial against the cops who assisted her in taking the child. And she testified at that trial about all of this stuff. And so she's already, out of jeopardy by the time we get to this deposition, which is crazy because once she's out of jeopardy, her case is over. It's been paid out. She's no longer in jeopardy. It doesn't matter if she tells the truth. She might as well tell the truth. That would take all the wind out of my sails, all the wind. If she just quit fighting, tell the truth about everything. I have no emotional energy to engage her. As long as she fights and lies and cheats, though, that gives me a lot of ammunition to go in there and, swing the bat. So that's one of the reasons that her lawyer is just sitting there silently letting this all happen, is because she's already been sued and already paid out. So there's no further liability here. And there's no point in him vociferously defending her because there's really no lose situation here. But what they didn't account for was the Monell claim. And under Monell, when we have a known bad actor who's not disciplined, who's not trained, and who's left in the field to just work out their angst on children and families, that goes directly to establish the custom, policy, practice, and lack of training of the county. Their deliberate indifference to the need for further policy changes, further training, discipline, etc. So that's what we're really doing this depo for. And that's why we're digging into these past cases with her, is to show that the county knows she's a bad egg, like a deeply bad egg. And yet they keep her there. She still has a job. She didn't get any additional training. She didn't get any discipline. Whatever discipline she got reverted. So all of that goes to establish our Monell claim in the Bruno case. So that's a little explanation of what's going on here.
And if Mr. Randall testified that he didn't know where she lived and that he got the address from you during your telephone call with him, would he be lying about that?
Yes.
Okay. If you look at this exhibit number 8, paragraph number 4, does it tell us anywhere there when the effectiveness of this order terminates?
October 28th, 2010.
Well, now, October 28th, 2010, that's months after March 2010, isn't it?
Correct.
So this restraining order was in effect at the time that you seized that child from Miss Randall without a warrant and gave him over to Mr. Randall that night, correct?
Yes.
And you made no effort at all that night to figure out why this order was in place or whether or not Mr. Randall was even a safe placement, did you?
As I've had contact with the Randall family. I was very much aware of their family court issues. From my understanding, during my previous investigation, they had a peaceful contact order. They communicated through some family law website because they couldn't get along. And that must have been after, if this was in 2008, I think I had my first contact with them was probably in 2009.
Are you done?
I don't know yet.
Okay, I'll wait.
Let me think. So I wasn't aware of this. I wasn't aware that they could not have contact with each other. As I've stated before, I believe it was a peaceful contact order.
Now are you done?
Yeah.
Okay, objection, move to strike non-responsive.
All right, well, there we have it. That was another fun night with Manisha Hammond. And, this was, 2017 or something. So how many years is that? 7 years ago? I don't know if she's still working there or not. I imagine by now she's probably been promoted to a training position or some sort of other position where she's out of the field and no longer capable of generating liability for the county. But who knows? Who knows? Most of the social workers that I sued do end up getting promoted. So, whatever. Let's see what we have. I don't have any caps and stems questions. I had some Patreon stuff come through, but they're not really questions. They're more like case consultation requests. And I don't think they're really appropriate for presentation here because they're just really not questions. But yeah, seemed to me move to strike. It's just to preserve the objection in case something happens and they want to try to use it at trial. Her answer was non-responsive to the question. You preserve your ability or your motion to strike it. Nothing actually happens at the deposition. There's no judge there or anything like that. It's really just sort of a snarky way of sending a fuck you to the testifying party. But that's basically it. Anyway, no caps and stems questions, no appropriate Patreon questions tonight. So I guess we'll just get, Eric, imagine these people training others. But regardless, that's where they end up. They get promoted and they get rolled into training. And that's very, very typical. So thank you all for attending tonight's stream. Please share the Patreon link one more time. That's a note from James. I just had my Biden moment. It's up. It's right there. It's like right there. But yeah. Anyway, tomorrow will be Maisha Hammond, Volume 1, Part 7. Remember, if you have questions or comments, please do email them into capsandStemslaw@gmail.com. I'll post that up. We do get the government we vote for. You know, I can't tell you how many people I talk to who voted for Obama and voted for Biden. They openly admit it. And then they complain about the shit we're dealing with. And it's like, dude, you voted for this. What the fuck? So yeah, anytime you're voting, even local elections, really don't cast your vote, you know, just on a whim. Really investigate the background of who you're voting for. Really look at what their true opinions are. How do they carry themselves? How do they live their life? Don't listen to what they say. They're gonna promise you that they won't come in your mouth. And then that's exactly what they do. So you got to go further than just listening to what they say. You have to look at what they've done with their life. How were they raised? Where did they come from? What have they done? You know, that's what matters. And, you know, if their life doesn't measure up, don't fucking vote for them. It's like Biden, man. The guy spent his entire adult life in politics. Why would you vote for somebody like that? They haven't done shit. You know, you want to vote for somebody, go out and find somebody who's run a business, who's had to meet a payroll, who maybe has been through a business bankruptcy because the market was so tough. You know, somebody who has some rough knocks they've been through out in the real world. Find that guy, vote for him. But you know, these people that have never had a blister, they don't know what it's like to dig a ditch or to fix a leaky pipe. You know, don't vote for those people, man. They're going to fuck you every single time. And people just don't get it. They want to vote for the fancy promises and pretty faces, and those people, they're just not capable. They're incompetent. And they're going to fuck you in the end. That's just how it is, man. So be really careful with your vote. Your vote has a lot of value. You don't want to just give it away. Oh, I could go on forever about this stuff. But anyway, this is not a political site, and it's not intended to be. And I know that there are people out there who are all fucked up in their politics, and they may get offended. So I should just cut it there. Anyway, thank you all for joining tonight. Remember, if you do have questions, please email them into capsandstemslaw@gmail.com. We'll try to respond to them during the week. There is the email address there in the chat. And I've published it again right there. And what else do we have? Oh, questions sent to Patreon. Since you're a Patreon subscriber, that is an added benefit. You get a more prompt response. And for those of you who did send Patreon questions, even though they're not really questions, they're more like requests for consultation, I will respond to those, but it'll probably be tomorrow. But generally speaking, an email notification gets sent to me if Patreon subscribers send a question, so I know it's there. And I do try to respond to those fairly promptly. That's one of the added benefits of being a subscriber at any level, even the $3 level. You're going to get a more prompt response. What else do we have? Just a reminder, if you're on YouTube and you look right below the video, there's a video description. If you click or tap show more, there are a bunch of links to catch up on, view past videos, the Patreon link, Spotify or Shopify, I guess. All that stuff is there. If you're not watching us on YouTube and you're on one of the other platforms like X or Facebook, I don't know what to tell you. Go to YouTube so you can click on the video description, I guess. I don't know. If you guys are enjoying the content, this one's really important, and this is probably the last one I've got. Please show your support by liking, by sharing it with your friends, commenting, encourage your friends to join us here, and subscribing to the channel. James tracks all of those statistics, and that's the kind of stuff, that growth is what really keeps him motivated. So please help us grow the channel. You know, in the end, we're doing this really for you guys. We started this as a project to try to help all the people that I can't help. We're case limited. I only take 16 cases at a time. There are literally hundreds of people that call every week with a lot of questions, needing a lot of help, and I just can't give it. So what we started doing is we started publishing the work on Patreon. We started doing this YouTube stuff. We started doing the office hours for people that are self-litigating their cases, or even for attorneys. We have a few attorneys that come in on office hours every now and then. And just trying to help people out that we can't, whose cases we can't take or can't get involved in. That's what this is all about. So I guess in the end, we're doing this to help you guys. And I really do hope the content that we're providing you does help you in some way, even if it's just for entertainment. That's, you know, better than nothing. You guys have a wonderful evening. Enjoy the rest of your weekend. For those of you who are either YouTube members or Patreon subscribers, remember we do have office hours on Discord tomorrow night at 5. And I'd love to see you there. Anyway, talk to y'all later. You have a wonderful evening.